Alright guys, listen up. This is our last week of new material for the semester, and I bet you are more than ready to be done listening to me talk to you about these concepts, but unfortunately we've got one more short lecture to get through, and then you can finish up your final papers, and then you can enjoy your break. So this week we're talking about the implementation of judicial policies, which I think, in my opinion at least, it's a very awesome way to end the semester. So you have a couple readings this week. You had 4, chapter 14 of the CARP text, the Baum article from 76, the Jacob article from 2013, and the remaining one, the Simon piece from 2008. So when we're talking about the implementation of judicial policy, what we're really talking about is that SCOTUS has made a ruling, and now it is up to the state or federal governments, whoever it may be referring to, they have to implement that ruling. So it's their responsibility to come up and create guidelines or change the way that current guidelines are existing, and they have to change the way they're doing something to remain compliant with the way that SCOTUS has ruled. So they have to remain compliant with the constitutional safeguards that have come into question in the specific case. So earlier in the semester, we discussed how SCOTUS ruled that the death penalty was unconstitutional in 1972 under the collective Furman decision. And the implementation of that case then forced states to sort of dissolve their current death penalty statutes. They had to commute the death sentences of all of those inmates who were currently on death row, and then they had to start restructuring how their new death penalty statutes were going to look in order to reflect what the Supreme Court had stated. So then when the court reviewed these new statutes in the collective CRIJ decision in 76, the states then had to sort of finalize and implement what the court's new recommendations were for the death penalty, with the inclusion of things like bifurcated trials and so on and so on. So this is really when lower level courts and individual agencies play a big role and come into play when we're talking about these things. So your textbook talks about the Miranda v. Arizona case, in which we now know to be one of the most famous police procedural cases that we have today. So it's at this point in 2017, it's almost like secondhand, or it's second nature that we are read our Miranda rights at the time of arrest, but clearly it wasn't always the case, and that's why we had the need for the court to make that ruling. But with the implementation of Miranda, there then had to be an agreed upon statement that would be read to potential suspects, or a specific warning, and everybody had to agree on how that was going to be worded. And then they needed to have uniform training for officers so they would know exactly what it was that they were supposed to tell suspects, and they had to make sure that they do it correctly, right? So if you are not Mirandized properly, then the court can throw out your case. So they had to make sure that they were doing it the way that they were supposed to do it based on the court's ruling in order to remain compliant. So for a long while, and still today, even some departments just give brand new officers laminated cards that they put in their shirt pocket, or they keep in their pocket, their pants pocket, whatever, wherever they want to put it. And those laminated cards have the exact wording of what the Miranda warnings are, so that they can specifically tell a suspect and get it right, so that they don't get their arrest thrown out of court due to a procedural error, right? So when this case came out, you saw how important it was to properly implement the court's ruling here, and that's what we're talking about with judicial implementation. And other times, though, it doesn't go as smoothly as it did with Miranda, right? There's less importance that's placed on the court's ruling, especially when there is a civil matter at play. There you see a little bit more resistance taking place. So earlier, there are 2 examples that I can think of with this resistance or this backlash, and both of which we've already talked about a little bit. The first one that I can think of happened with same-sex marriage, when we talked about the Kentucky clerk who decided that she was not going to hand out marriage licenses, right? So a ruling has taken place. I don't agree with it. I'm going to stop what I'm doing to protest the ruling. The second one that I'm thinking about is a little bit more detailed, a little bit more specific. excuse me, so this case that I'm thinking about happens to do with the Little Rock Nine, and hopefully you guys have heard about the Little Rock Nine long before I'm talking about it here. Hopefully that just saying it though sparks a light bulb for you. But the Little Rock Nine is a very interesting case in which 9 black students were trying to enter a newly integrated Little Rock Central High School in, I think, 56 or 57. So this is post-Brown v. Board of Education. So remember earlier in the semester we talked about that case. In the Brown case, what it did was basically it overturned the Plessy versus Ferguson ruling, in which the court decided that separate but equal is no longer constitutional, right? So in 1954, SCOTUS ruled the Plessy case is unconstitutional, changed their mind, and set new precedent. So separate but equal is out, so that means that everybody has to get together, right? We now have to integrate. So the Brown v. Board case then paved the road for school integration and was sort of the landmark case that sparked the civil rights movement. So despite the fact that SCOTUS said that you have to integrate, the actual application of integration didn't go over so well at first. And one of the biggest national issues arose in Little Rock, Arkansas, with the Little Rock Nine. So it's a new school year, and the Little Rock School District is trying to make preparations so that school integration can go smoothly. And when the new school year began in, what did I say, like 56, 57, 9 black high school students were then assigned to go to the Little Rock Central High School, which was in their neighborhood district. And the governor, George Wallace, decided that he was not going to allow this to happen, and basically brought out the Arkansas National Guard to make sure that these 9 students did not gain entry to the school. So President Eisenhower at the time then hears what's going on, and he said, oh, no, you let those kids into school. And the governor refused, so President Eisenhower then tried to de-escalate the situation even further, and when that didn't work, he basically said, I'm sending out my army, and you're going to let these kids go to school. So he federalized the National Guard, which then took power away from Wallace and made the Arkansas National Guard under Eisenhower's control once again. And so then after Eisenhower made these 2 attempts, Wallace had no more power, and these kids were allowed to gain entry to the school, and they got to go to school in the Little Rock Central High School. So at least for Arkansas, this was the pivotal point in which racial integration really began in that state. So the Little Rock Nine, I always think, is just this classic example of resistance from individuals who don't necessarily agree with the Supreme Court's ruling and are trying to make attempts to, and the state's attempts rather, to implement policies that come from the Supreme Court. So, this is going to be just a quick little lecture because I know that you guys have a lot to still do with your papers and things. But I just wanted to stop in and talk to you for a few minutes because the textbook and your readings go on to cover everything in a more in-depth level, and your final weekly presentation will do that for you as well. It'll delve a little bit deeper into these topics. So I'm going to leave you there, and I'm going to let you all get back to work and get back to your readings and your discussion boards and your weekly assignments. So at this point, I don't have any more short lectures for you, which you might say, okay, that's really sad, or you might be super thrilled. So either way, remember that next week you have your final paper that is due to me, and make sure that you check the syllabus to find the exact date and time in which it is due. And if you have any other questions, please let me know. This is the time to get in touch with me before those final papers are due. And if you don't have any questions, then I just wanted to say that it was an absolute pleasure having you this semester, and I really enjoyed getting a chance to talk to you about these different topics involving judicial policy. So I look forward to reading your final papers, and I hope you all have a good break. So thank you. Bye.